Hi, I'm Sean Ricketts. I'm a paralegal at the law offices of Jacob Aronauer.
Hi, I'm Jacob Aronauer. I'm an attorney at the law offices of Jacob Aronauer.
Hi, I'm Karin Weston. I'm a paralegal.
I'm Elena Mullins. I'm a former employee of the law offices of Jacob Aronauer and a current friend of the law offices of Jacob Aronauer.
And we're very happy to have her back.
So I'm going to be reading some letters from the mailbag today. And the first letter is from Jessie, who writes, I am a transgender woman and have worked for the same company in Manhattan for 11 years. Around 6 months ago, I made the decision to begin transitioning and was fired within 2 months. I was relatively high up in my company at this point, and I have since not been able to find a job with as good a salary or benefits. Do I have a discrimination suit?
So this is a great question, and especially topical this week, because this week the Supreme Court has actually ruled that on a federal level, transgender discrimination is unlawful and covered under Title VII of the 1964 Civil Rights Act. According to the majority opinion in that case, they stated an employer who fires an individual merely for being gay or transgender defies the law. In New York City and New York State, transgender people have also been covered in terms of discrimination. They've been protected since the early 2000s. And the New York City Human Rights Commission's guidance states that it is unlawful to refuse to hire, promote, or fire a person because of a person's actual or perceived gender, including being or being perceived to be transgender, non-binary, or gender non-conforming. And they go on to provide more guidance. If you're interested in looking that up, you can look on the New York State website. So Jessie definitely could have a case, but of course with all discrimination cases, we do ask what kind of evidence is there to show that your termination is due to your protected characteristic, your gender or your gender identity, and not for some other reason that is lawful. So we would ask you what other circumstances surrounded your termination and other things. Karin, did you have other specific questions you wanted to bring up?
Yeah. In terms of trying to build one of these cases, we want to think about, how did your coworkers or your boss or bosses react when you began transitioning? Were there any comments that were made that were inappropriate? Is anything in writing? Do we have a text or an email that would show any of these things? That would be really helpful in building a case. If anything happened, did you complain to HR? Do you have a record of that? Those sorts of things. We really want to know, like, what were the circumstances of you getting fired, so that we would know that that was something that was based on discrimination and not based on a different reason.
Right.
I would also maybe, I'm sorry, go ahead.
Sorry, we would also ask if there were any previous performance reviews, good or bad, that could support your contention that you were a great employee with no other problems.
Right. Yeah, I mean, I was going to add to that, and Sean more or less said it, but not just looking for the bad stuff. I would also want to know anything good, like, did you routinely get good performance reviews? Did you routinely get promotions? Did you routinely get raises? If you were just sort of a floundering employee and then you happen to be fired, that would make it a tougher case.
Ready for the second question?
Sure.
This one is from Manuel. I am a Dominican citizen working as a delivery worker for a busy restaurant in Brooklyn. A couple weeks ago, I heard one of the other delivery workers mention how much they earned, and it was significantly more than me. This other worker has papers, but I do not. I started asking my other coworkers how much they made because I felt it was unfair that I was being paid less. One day, my boss overheard us discussing wages and told me to stop and to go home. Afterwards, he called me and told me that I was no longer needed at the restaurant because they had enough delivery workers, but I think I was fired because I was asking my coworkers about their pay. Was this legal?
Yeah, so thanks for running in, Manuel. That's not legal for your boss to fire you because discussing your pay is something that we call protected activity. And when you are engaging in protected activity, your boss cannot retaliate against you, and firing you is a form of retaliation. So your rights to engage in protected activity are protected both federally and on the state level. And the New York labor law especially is pretty clear about how, yeah, discussing pay is really something that's protected. You might wonder, like, okay, so getting fired, that's definitely a form of retaliation, but what other things could count as retaliation? So we have a nice little list here. So dismissal from employment, first thing, cut in work hours, being rescheduled for less desirous hours, reassigned to a less desired work location, a cut in pay, failure to give promised or customary raise, disciplinary action, more intensive or critical supervision, demotion or transfer, withdrawal of previously allowed privileges, assigned to more difficult duties, things like that. So, yeah.
I would just like to add, oh, I'm sorry, go ahead, Sean, I apologize.
No, just to add, talking about retaliation, that covers protected activities, not just talking about your wages, but also if you were to make a complaint about your employer, either to your employer or to the commission in New York. So if you ask your employer, why am I not getting paid appropriately for overtime, and they fire you or do any of those other things, that's also considered a protected activity.
And what I would advise an employee, if they think their employer is trying to basically force them out for engaging in protected activity, such as cutting hours or less desirable work schedule, constructive discharge, unlawful constructive discharges, cases are very hard to prove. So what I would recommend to the employee is not to be a big hero, but to tough it out and get a lawyer involved, have the lawyer contact the company, and then hopefully then you could maybe reach a resolution. But I recognize it's a very uncomfortable situation. The term I use, that when you complain to a boss, when you engage in protected activity at a place that you work at, and then you continue to work there, it's basically the equivalent of living with an ex. But just to sort of deal with it and then get the lawyer involved.
Okay. Our last question is from Angela. I was an attorney in a white shoe law firm. I think I may have been fired because my boss thought I was a lesbian. Allow me to explain. While I have always liked men, I admittedly have stereotypical lesbian features. I have short hair and never wear dresses or skirts. I also play rugby. My male immediate supervisor frequently criticized the way I dressed, saying I did not dress ladylike. He also often asked when I was going to bring my, quote, partner to the office, but I told him several times that I was not gay and it was not his business who I dated or what type of people I dated. He would just laugh. At the firm Christmas party, my boss got drunk and I overheard him saying, using my name, "She is ugly even for a lesbian." During COVID, my department had layoffs. Within my group, none of the other women were laid off, but only me and two very junior men. My work product has always been good, and I think I may have been laid off because my boss thought I was a lesbian. It is also worth noting that my boss is very religious, and I get the feeling that he thinks being gay is a sin.
Okay, so I'm going to take this one. A lot going on. So first, yes, you definitely, even if you're not gay or a lesbian, but your boss thinks you are, you could still potentially have a claim, not just under the New York City or New York State human rights law, but as Sean was talking about earlier, now under Title VII, you would have a claim as well. And I wouldn't say that's something we see a lot, but it does happen often where a supervisor or the owner of a company makes an assumption and then a problematic situation occurs. The second thing is with respect to COVID, and I'm sort of just kind of making general statements admittedly, is that if a company is not making as much money or is afraid that they're not going to make as much money, or their business has effectively come to a halt or slowed down significantly, they are allowed to furlough, they're allowed to lay off people. It's still employment at will. But if they're laying off people, they're basically saying, okay, we're going to keep the heterosexuals and we'll get rid of the lesbians or something like that, then you would have a case. So you can lay off people, but you can't do it in a discriminatory manner. So, those are just sort of general observations in terms of whether or not you would have a case. Obviously, again, I would have to get more details.
Yeah, just looking at this, it also seems like there might be a claim for hostile work environment due to sex discrimination because of that fact pattern of many criticizing comments that are specifically about how she dresses because she's a woman. That's why those comments are coming up. I'm assuming that her boss is not telling men that they're not dressing appropriately, although maybe they are, and that would be a wider problem since that's really not acceptable either. But essentially we would ask her questions to try to discern, like, how many times were these things being said, over what time period, do you have exact quotes, is there anything in writing? Similarly to what Karin was saying with the first question, we're really interested in gathering as much concrete evidence as possible.
Right, and I would just maybe add to that depending upon how egregious the question or statement is, then how often it was said would be not as important. So for example, the Christmas party comment by itself, that's pretty bad, and that arguably could maybe make for a hostile work environment. But hypothetically, if you were just to say once in a span of a 5-year employment, hey, I think you should wear dresses instead of just pants all the time, well, not appropriate, and I wouldn't say something like that. I'd recommend to my clients not to say anything like that. I don't think that would be a very good basis for a lawsuit. So you sort of, as Sean was pointing out, have to look at everything collectively. So I think that's it. Those were the 3 questions, correct?
Yep.
All right. Well, it was great to have you back, Elena, for the questions, and hopefully in a couple of weeks we'll have some more questions.
Great.
Bye, all.